the estate of Stanley Corwin, estate number 99997.
Good morning, Your Honor.
Good morning.
I'm Marcy Stevenson. I represent Mr. James Corwin, who is in the courtroom next to me.
Okay.
Good morning, Your Honor. Adam Spence, counsel for Stephen and David Corwin.
Are your clients here or they're not here?
I have one that lives in Costa Rica and one that lives in California.
Okay.
So they're not here with me today.
All right. They don't need to be. I just wanted to know.
Yep.
Okay, and Marshall Stevenson with James. Okay, we have two issues, two motions. The motion to require the co-PR James Corwin to repay improperly taken estate funds, and the second one is the motion for reconsideration and the opposition to motion for reconsideration. So let's hear the first one, the motion to require repayment.
Thank you, Your Honor.
Your Honor, first, I heard what you said, and
Okay.
perhaps I'm a bit ignorant, and I'll concede to that, but the nature of the allegations are personal to the parties, i.e. Stephen, Corwin, they're both brothers, and David. I'm not sure how we will have or could have a hearing without them.
Okay.
I know you're the judge, but I need to understand because I want my client to be able to respond in the way he needs to. And so that's why I'm asking when you say they don't need to be here. I don't...
Well, usually for motions hearings, it's just the attorneys arguing the case. Are you telling me that you wanted to be asking questions?
Oh, absolutely. Well, if you look at one of the motion, and I responded to the motion, and the caption, just using the caption, is improperly taken money. No, there is no plume that says this is improperly taken. So that's a conclusion someone made, and given the context, and I'll say context because from the very beginning, this has been one of undue influence. He's stolen the money, so on and so forth. And that can only come from the parties in a meaningful way. And so if the court sees otherwise, but I was reviewing the paperwork all this time, and this has been going on for over 2 years now. There have been many motions, withdrawn motions. The parties have never been here. And I'm not trying to tell the court how to run the court, but it's one of those things where us lawyers can only know what our clients tell us, but for me to cross-examine, I believe we should. That's America. I can't do it with an attorney trained to evade questions, answer when they think it's needed. And that's not even disparaging Mr. Scott, but simply we don't get anywhere. And so, because the things that are said in the motion are pretty substantial and hurtful. They're very personal.
Okay.
The second one, I'll address the second one. This court, it was about the subpoenas. My client had done the motion for a protective order. The court denied it. I did the motion, and yes, the motion. But the court also did a show cause order. And if the court looks at the file, you'll see that I answered because that Friday when I looked, the court said in a hearing without realizing that the show cause was never complied with. So I did a motion to dismiss the show cause. And we take it very seriously because if we keep going on like this with hearing, and I must say, Judge, I know I'm going around and around, but a lot of it is very filling inside, and so I'm giving it to you before we have to do the brass tacks of what we do. We could just be going on and on and on about hearing versus not hearing. And I must say, we know that the motion that the parties filed, it's not a show cause because you don't ask for a hearing with a show cause. So it's that the court's order is being ignored. And so, yeah, that's a motion. But it's a kind of thing, Judge, I think it's really in your ballpark. There's a show cause order, and the court did it for a particular reason, given estates and trust articles, the rules. And there have been, it was never answered, and there was nothing from the court about that. I don't know what we can say about that. I brought it to the head as best I know.
So to answer your last point, in reality, when there are motions filed, really what we want is a response to it. And I understand a show cause order was sent out, but we consider the response, the opposition to motion for reconsideration, to be the response. So we don't need another response to the show cause order, because really what the show cause order is saying, tell me why I shouldn't rule in the way that the motion for reconsideration requests. Right. So the opposition gives that response. So that's my ruling on that issue. With regard to the others, let me go to each one.
So is there a written order from the court saying that motion is proper? Is that what the court is saying?
I'm going to say that today. That's what I'm telling you. That when a motion for reconsideration is filed, really what we need is a response to that motion. So the response is the opposition to motion. Okay.
Very well. I was going by the rules, Your Honor, which says you respond to what is asked of you. And that's fine. I understand. I understand.
All right. With regard to the first issue, the estate funds. So this court issued an order on March 20th allowing $3,571.43 of James's claim. All right, so I can hear what I envisioned today was the argument about, did he actually take $10,000, and if he did, then he needs to repay $10,000 minus $3,571.43, because this court ruled that that's what he's entitled to, when originally he said that he was paying, on his first accounting, he said he paid himself $20,000. So, and David and Stephen alleged that he took $10,000 from the Charles Schwab account 2 days before. So that's what I wanted to hear from James. What money did he take? And did he repay all but $3,571.43? So I want to know from him, did he repay this money? So I don't need Stanley and
David and Stephen.
David and Stephen for that purpose. This is about, I ordered $3,571.43. If he took more, then did he repay it? That's that discussion. So
the characterizations of improperly paid, which obviously offends me and my client, is not what the issue you're looking at. You just want to know what happens to the money per that contract.
Right. That I allowed, according to my court order.
Okay.
So did he repay the rest?
Very well.
All right. And I'm not sure whether he took $20,000 or $10,000. So that's part of the discussion too. Did he take $20,000? If so, he has to pay $16,428.58. If he only took $10,000, then it's less than that. Yeah. That's that issue.
Your Honor, if I may clarify, it's actually not 20 versus 10. It's 20 versus 30. What we showed in Exhibit C of the supplement was that the Charles Schwab records, which were attached as Exhibit C, showed that $10,000 was taken on 2/8. $10,000 was taken on 3/4, and $10,000 was taken on 4/1.
Okay.
And then Your Honor they only disclosed to Your Honor the second two payments of 3/4 and 4/1.
Okay.
And so what we were asking for, and in addition to that, and the improper taken, I mean, the court order said it's improper, it needs to be returned. Or it didn't say it needed to be returned, it said it's improper, it's not permitted as part of the accounting, which makes it improper. And I don't need my clients here to say that. I think the court has already said that and said this is improper amend the accounting, that money should not have been paid by the estate.
Okay. So the issue is how much was taken in their.
The dubious thing is taken. The dubious thing is taken. And if my client gets on the stand and we get to it, we will address, because taken is one of those dubious terms. And without going into it much, you will see, Your Honor, that it was an automatic payment from a particular account. And so the first payment pursuant to the contract was on when Mr. Stander was alive. Therefore,
we're going beyond. I mean, we just wanted to talk preliminarily about what we're doing, and then we'll make the arguments.
Okay,
and we can talk about it.
Well, I get riled up when I hear about taken improper. I didn't see an order that said was improper. Nobody's stealing from anyone, Your Honor. So we can just leave that out.
This is really just a numbers discussion.
Well, I hope so. We just leave the name calling alone.
All right. And then with regard to the protective order, so we have I ruled on it, and then the question is just, is there reason to change the ruling based on a need to do discovery about whether there are other assets that weren't mentioned, that weren't previously revealed? So I don't think we need David and Stephen to do that. We can have the argument.
Well, I pretty much conceded to that. I conceded that you wouldn't need in terms of that. Okay. However, I was just, oh gosh, I'm getting old and I just lost my train of thought. Maybe it's a good thing. I'll just surrender for a moment. I don't remember what I was going to say.
Okay, so basically, why don't we get started and we're going to hear arguments on the motions.
Very well. Which one do you prefer to do? The earliest is the Stephen and David's.
The motion to repay funds.
That's what I had scheduled as first. So
if I can call Mr. Corwin to the stand and we'll just go through it just for evidentiary purposes, just so we can establish.
Okay, and you said I just want to get all the proper documents in front of me. The one that you said that has the Schwab accounts on them.
And do you have the contract, Your Honor? I see it in your inventory, home care, but I didn't, and it's mentioned in your order, but I don't know if you have a copy in front of you, because I didn't see when I went to look at the court file.
I have so many pieces of paper here. I'm not sure if I have the contract or not. First thing I wanted to find was which attachment it was with the Schwab accounts.
It was on the supplemental
motion.
It was Exhibit C. I have a copy, Your Honor, of the printouts with a declaration of custodian of records, which I'll introduce as Exhibit 1, in addition to what's been supplemented.
Okay.
This document.
I just want to have it in front of me before you make the argument.
That's fine.
Now, Ms. Stevenson, you wanted to know if I had the contract.
Yes, Your Honor. I have Mrs. Scott. Hello?
Oh, Spence. I'm sorry.
Spence.
That's okay.
Is your first name Scott?
No, it's Adam Spence.
Oh.
That's okay.
No, I'm not giving it to you. I'm intending to look at it for you to the job and see what
the contract is also attached as Exhibit A to my motion, my supplemental motion.
Just a second, okay, while I find it. Oh, okay.
That's what it was.
Because that's the whole issue.
Right. Okay, so here is the residence.
And the
Secure agreement. This is what we ruled upon since this is what we agreed to pay him $10,000 but he died a few days after this was executed, so that's why we went to order for $3,000. So this is the civil reserve of that, and that is the Charles Schwab information.
Okay, now I have it. Okay, so first we are doing the motion to repay. Okay, let me just get that in front of me. This is
Thank
okay.
you, Your If I can call Mr. Corwin to the stand, please.
He wants to be addressed as Dr. Corwin.
Okay.
That's his right.
If I can call Dr. Corwin to the stand, please.
Right.
Raise your right hand, please. Do you solemnly declare or affirm under the penalty of perjury that the testimony you're about to give will be the truth?
Yes, I do.
State your full name and address for the record, please.
James Edward Corwin, 1400 Lancaster Street, apartment 309, Baltimore, Maryland, 21231.
You may be seated.
Good morning, Dr. Corwin. Do you recall a time when this court entered its order that stated that it would permit of the $20,000 that was included, or that it disallowed the $20,000 in payments to you that were provided for in the first accounting?
Did you say, do I recall the
Yes.
time?
Do you recall? I mean, well, let's start with the beginning. In your first accounting, you listed $20,000 in payments to yourself. Is that correct?
Yes.
Okay, and were those monies received by you?
Yes.
Okay, and you recall that the court issued an order asking you to explain those payments?
I believe there was an order to do that.
Okay, and your explanation was that it was pursuant to a home health care agreement. Is that correct?
I'd have to look at the actual explanation.
Okay. I'm going to turn your attention to what is Exhibit A to the supplement that I'll mark as Petitioner's Exhibit 1. May I approach?
Yes.
Dr. Corwin?
May I see what you're showing him?
It's Exhibit A to my supplement.
Very.
Mr. Banks, just record.
You can just take a look at that document and identify that document.
Yeah, it's a letter from the attorney who was representing the estate.
Okay, and
responding.
Okay, and so the payment referenced that it was pursuant to a residency and care agreement dated February 1st, 2013. Is that correct?
Objection, Your Honor. Is it what he did or what someone else did? I think we want to know what he did, Your Honor, and we're showing a letter that's from someone else.
Well, I think his testimony was that he doesn't remember his response, so I'm telling him this is
Well,
his
that letter is
response.
not his response. That's an attorney's response.
So what is your point in showing him the letter? What are you doing?
I'm trying to get a reason why he paid the money, why the $20,000 was paid to him.
Then ask him.
I asked him, and he said, I don't remember my response.
Then you got an
so I
answer.
gave him the
Ask an
response.
answer.
So you could ask him to please take a look at this letter, and does that refresh his memory of what happened?
Does this refresh your recollection of why you took the $20,000?
I don't need this letter to know why I was paid.
Okay, why were you paid?
To provide home care services
Okay.
for my father.
And that was pursuant to the February 1st, 2015, February 1st, 2013 residency and care agreement. Is that correct?
I'm not sure what pursuant means, but that was the contract was the culmination of 2 months of preparation and planning to bring my father home to live out his last however many days of life that he had left.
Your Honor, the Exhibit 1, I don't need to admit because it's already before this court as a response to the show cause order, so it's part of the record. I can admit it as Petitioner's Exhibit 1 simply for reference purposes.
And Exhibit 1 is this letter?
Yes.
Okay.
And I'm going to object to its admittance, Your Honor, because it has, counsel has not established a purpose for it.
Let me find the letter again. talking about the letter from Eric McClellan?
Yeah, from Eric McClellan was your attorney at the time, wasn't he? Is that correct?
As I understand, he was the attorney for the estate, but as I'm beginning to understand, that attorney also represents the personal representative. So he was representing the estate at that time.
Yeah, I mean,
McLaughlin.
it says what it says. It was his response to the show cause order why the $20,000 was taken.
No.
What's your objection?
Can I, if I'm on a witness stand, can I ask you not to say the money was taken? If I go to the supermarket and I pay $2 for milk, the supermarket's not taking $2 from me. So I really object to that use of that word.
When your father
I can see it to my client.
When was your father admitted to Gilchrist? Hospice care.
Hospice. End of January?
February 1st, 2013, the same day as the contract that you say you signed. Is that correct?
He didn't sign the contract.
He
My
didn't
father
sign
had a stroke.
Objection.
He didn't sign
Would
the
counsel
contract.
allow my client to testify? If he wants to testify, he can go up and say as much as he wants.
So, I mean, he's asking cross-examination questions, but
But
let's
it's
go back.
indirect. He called him.
First, it's an adverse witness. First of all,
I'm having a hard time because every time she says I can't ask him questions because they're
No, that's not what I
then
said.
I ask him a different question and she says I can't ask that
Because they're not proper.
I'm having a
Counsel.
very difficult time actually putting on my case because of improper objections, Your Honor.
Well,
okay, first, let's go back. There was an issue about whether we're allowing this to be Exhibit 1. So I'm allowing it. It's already in the record.
Thank you.
Okay, so that's the first thing. Now, Dr. James Corwin, even though he was called on direct, he is an adverse witness, which means he can ask the questions in the way that he's asking them. But if you have an objection to a question, you can stand up and you can raise the objection, and then I will rule on it. Okay?
Let me just say, Your Honor, when my client testifies and he thinks it's a better answer, he says the better answer to my client. That's not cross-examination, and that's not proper.
So he can say, is this your answer? That's part of his
But
cross-examination.
don't tell him what he should have said. I mean, it's just,
That's
not the
how
way.
cross-examination
That's
is
not,
done.
no, that's not how. 30 years of doing this, Ron, that's not cross-examination, confronting. Well, he says, isn't it correct? At least make it sound like a question. But anyway, I'm sorry, Judge, I just...
May I continue, Your Honor?
Yes.
Thank you. Isn't it correct that plaintiff's, what I've handed to you as Petitioner's Exhibit 2 is the agreement pursuant to which you paid yourself $30,000?
Yes, this is the contract that we drew up to provide residency, home care to my father, yes.
At this time, I'd move to the admission of Plaintiff's Exhibit 2, which is the residency care agreement, which is also Exhibit A, pages 2 and 3.
And I have no objection.
Okay, it's admitted then.
Thank you. And your father didn't sign this on February 1st, is that correct?
That's right.
How come your father didn't sign it?
My father had a stroke right before Thanksgiving, and his health was declining. It was a shock to him. He was relatively independent. He was quite independent, with some help on his financial matters, and other little things, like reprogramming his TV remote control and his microwave. I had help with things like that. When he had a stroke, it was around November 19th, it changed his life, even more than when my mother passed away several years prior to that. That was a great shock to him, but he was recovering from that, and then he had a stroke. Here was a man who was a decorated combat veteran in World War II. He was dropped behind enemy lines. He faced enemy fire. He was hit by bullets. None of that prepared him for dealing with the loss of his left side, the strength in his left side.
Okay, so
And he essentially gave up, and he was in rehabs. He hated the rehab. He begged me to take him home with us.
okay, so fair to say at the time that he
Let
I
him
did
let him
everything that I
finish.
could to make my father And I was there every day with him. The nurses' aides were treating him roughly, and I was trying to help him.
Okay, so on February 1st...
And in order to get... I talked with one of my brothers, who was still talking to me at that time, about bringing Dad home with me, and of course I would need to get paid for it in some way. I had to take off work. I was going to do all the services myself. I'm a physician. I've dealt with families for hundreds of times that have gone through the same thing, but this is the first time I had to deal with it myself. And I was the one that was going to clean up my father after he defecated in the bed because he lost control of those things. And I was going to provide these, and I couldn't do that if I was still working.
Okay, so on February 1st, you signed this
Can you
agreement.
are you finished?
Well, we
can you
stay
finish
here
the?
for several hours today.
Oh, and I want to.
Okay, counsel.
Or I can answer
Dr.
questions.
Corwin, are you finished with your answer? With his question?
The question was why he couldn't sign it. And my father was debilitated and
Physically unable.
Stop objection. Stop
he
testifying.
physically could because he had a right hand. His right hand worked and he was right-handed, but I mean to have him scrawl his name on a piece of paper, which quite honestly the paper is just a piece of paper. I knew what services I was going to provide for my
Was he
father.
mentally aware of what this document was?
The fine details, probably not. But the general concept of him coming home to live with me and that he was going to pay me for that, yes, he was aware of that.
Okay, go ahead, counsel.
You're a physician, correct?
Yes,
Internist?
family practice.
Family practice. So you understand what advanced stage dementia?
I do, yes.
In fact, in-stage dementia?
I know about that.
Okay, and what is in-stage dementia? Or advanced dementia?
Probably two different things. With dementia is advanced, cognitive decline, loss of short-term memory, and the more advanced, basically, is reverting back to an infantile state, to put it simply.
And your father suffered from this as of February 1st, isn't that correct?
Advanced dementia or
End-stage
end-stage?
Alzheimer's dementia?
He obviously had cerebrovascular disease because he had a stroke, and that, yes, probably had some effect on his cognitive functioning.
So on February 1st, were you aware that Gilchrist Hospital in a memo states, consent signed by son, this was for the admission papers to Gilchrist, consent signed by son James as a healthcare HCD, which would be you, as patient is cognitively and physically unable to sign? Would you agree with that statement? That he was cognitively unable to sign as a result of his end-stage dementia that he was suffering from on February 1st?
Not because of end-stage dementia. No.
Okay, so he was cognitively unable to sign because of some other reason?
Well, most likely, yeah.
Okay, what other reasons would he have for not being able to sign for his admission?
My father didn't like the food. We went from the rehab, because his 28 days of Medicare ended. I wasn't ready. I didn't have the house ready. We live in a 2-story condo in the Inner Harbor area, Harbor East, and it's not set up for a bed-bound patient. So I had to do a number of accommodations to the condo to get it ready. And during that time, we had him in a respite care at Symphony Manor, assisted living facility, which he liked a little bit better than the rehab, but he hated food there. And he was probably also some level of depression too, and he was not eating. And I suspect that had a lot to do more with his dysfunction cognitively than any other process.
And are you also
Which was
aware-
something I was, hoping to reverse by getting him home. He really thrived on dining and home-cooked meals, and I thought we got him home and we'd start getting him eating, that he would rally, is the term we use.
And are you aware that on January 31st, as he was being interviewed for admission to Gilchrist Hospice Care, they found the patient was not oriented to person, place, or time?
So just 1 minute. Mr. Spence, my understanding of this hearing was about just money, whether that this court already ruled how much Dr. Corwin was entitled to.
Okay.
And the question is, did he repay did he repay the other funds that he had already paid? He paid himself for the care. This court said he was only entitled to $3,571.31. So I want to know, did he return the additional money? And that's all we're doing with this motion right now.
Right.
We're not questioning, this hearing isn't about whether this agreement was properly signed or not. I mean, that's not where we are.
I think they put it at issue by saying the money wasn't taken, and I just wanted to clarify that. And I'll move on.
Okay, because we could be spending an hour and a half on what you're doing, and that's not what this hearing is
Point well
about.
taken. I think we've established the circumstances of the contract.
Okay, so we just want to know whether, how much money needs to be repaid, and whether any of it was repaid.
So, pursuant to that contract, is it fair to say, or is it correct, that you received $30,000 from your father's Charles Schwab account?
Yes, but if I may, with all due respect to the court and your honor, when that was disallowed many moons ago, I did not agree with that ruling, by the way. And I did get something in the mail saying I had 20 days to file an exception to the ruling. But at that time, we had a different will. I don't know if you know the history of this thing, but my father's last will and testament, he left all of his money to me. And at the time, whether or not I paid back the estate that $17,000 or not didn't matter, because it was all going to come to me anyway. So it wasn't hugely important to me to fight that. I know Eric McLaughlin did submit that letter in response. I didn't think it was an adequate response, quite honestly, because it really didn't explain that this was a valid contract, that I put a tremendous amount of effort into getting my father home with me, and I didn't understand why the court disallowed it, other than the fact that, yes, my father passed away 10 or 12 days into the contract, and therefore it disallowed 5/6 or whatever of the payment. I mean, I understood the math there, but I didn't think the court really knew the whole story.
So the whole story was you had a will that gave you everything. When was that will signed?
October, August. I don't remember. Honestly.
Okay.
It was in 2012.
While your father was suffering from dementia, Alzheimer's dementia.
Well, we never got to find out whether that was a probatable last will and testament, because my brothers filed a caveat.
Because it was withdrawn as part of the caveat.
And what happened is that we fought over this thing, and they accused me of undue influence and all these other things, but we never had a hearing on the thing. But I decided, because there was such strife and argument over that will, that I just didn't think that we could use that will to settle my father's estate, because I figured it would just drag on forever. So I ceded that caveat, and we went back to his penultimate will and testament, which is the one that is in probate now. And so that now, by me paying back $17,000 to the estate, but money that I still believe that I earned for providing home figure pursuant to that agreement, that I shouldn't have to pay that $17,000 back, because my brothers are now going to get 2/3 of that money, which was money due and legitimately payable to me for services to my father.
And it wasn't just $17,000; it was actually $27,000.
Well, it was not actually, according to the court. The court only disallowed $17,000.
Now, you only disclosed to the court 2 payments of $10,000 each, not the third payment of $10,000.
That was
Is that
the
the
first
first
payment.
Right. So there
The
was three
$10,000
payments of
was a
Wait,
first
only
payment.
one person can talk at a time.
So there was 2 payments that you disclosed to the court. Is that fair to say? In that letter that we
2 payments from my father's estate after my father passed away that came to me. Yes.
And there was a third payment that you didn't disclose to the court that was made pursuant to that which you just testified to.
There was a first payment.
Okay, a first
In
payment.
February,
He's
that my
already
father
said-
paid to me
excuse
while
me.
he was still alive.
He already
I'm not
said-
denying that. My brothers knew that. It was
Dr.
in the
Corwin,
papers I sent to my brothers months
Dr.
ago.
Corwin, I hear what you're saying.
This is why my brothers should be here, because they're the ones that are leveling these accusations at.
I hear what you're saying. What happened is you gave up because of time, because of different issues that were going on. You didn't want to have the continued argument. You gave up the caveat issue, and you didn't contest the exceptions because you thought it was going to come to you anyway. The problem is that the time expired. So I hear you. I understand what you're saying. And unfortunately, at this point, it's really just a math part. And the fact that this residency and care agreement begins February 1st doesn't allow you to get paid for the work you did prior to that time, which is what I think you're saying, that you did a lot to prepare for your father to come home also. But unfortunately, this agreement doesn't say that. It commences February 1st. So you can only get paid from February 1st until February 10th. So I understand your point. It's just that I'm bound by the documents and by the times of expiration and things like that. So that's what we're here about. All right. I hear what you're saying. I understand your problem and how you feel, but it's too late to go back to the things that you didn't pursue, and that's just where it is. So what we have is that there was $30,000, and this court said that you're allowed $3,571.43 because that was the information that we had at that time, and so that's all. That's what it is. So,
and at this point, you haven't paid back the money that the court did not allow. Is that correct?
Yes. The plan was that we were going to do this at settlement. At settlement, $17,000. You know, I always have trouble with the math on this kind of the accounting, but it simply would come out of the accounting. My brothers would get proportionally slightly more than I would, because the $17,000 was going to be accounted.
Okay.
And that was the way I was intending to deal with this. This is what I spoke with the state's attorney, the current state's attorney, and it seemed like a reasonable way to handle it.
So Your Honor, just for clarification, the amount is $26,428.57.
And for my point of clarification, yeah, that's not the amount that was disallowed by the court. But I just have another question, though. So the court gives this leniency, allows my brothers not to respond to a show cause order, but then tells me that I don't have a chance to go back and revisit something?
This isn't an opportunity for you to ask me questions.
Okay, I'm sorry.
Okay.
And then the second point of clarification was there's a minimum. I added that to the contract because I didn't know how long my father was going to survive. And for me to put the time, the effort, take the leave of absence from work to commit to full-time residence care of my father required a certain minimum. Just like, I don't know, there's many businesses that require a minimum amount.
Yeah,
and if you don't,
You're finished with your...
I'm finished with the witness.
Okay.
He's not being responsible to any questions.
Objection, please. The commentary after he's sitting down, if he's finished, we sit. There's no need to say he's not answering. I mean, it just, if not, it's the
responsive
order.
to any question. He's just...
Well, then just lawyers don't do that.
He's finished with his case.
Thank you.
Okay. All right, Ms. Stevenson.
Yes, Your Honor. Thank you. Dr. Cornu, what was your function with your father in terms of handling his affairs? Did he give authority to you to do that?
Yes.
Okay, I'm going to show you what I marked
That's fine.
as, I guess, defense one for identification.
Do you have a copy of that?
It's my own one. I didn't know you were going to go away from that. You've never seen it?
I don't know what it is.
It's the power of attorney.
I thought that was the last written testimony. That's the last written testimony.
Oh, really?
Yeah.
Thanks. I take back everything I said about it.
Okay.
Pardon me, Your Honor. Madam Clerk, I meant to do this. what's been marked as Exhibit 1. Would you tell us what it is? It captions on the front.
Yeah. So it's the general power of attorney that my father gave to my brother Stephen and me.
And it's signed. What date is that given, sir?
July 23rd, 2010.
And that power of attorney, does it give you authority over, well, it speaks for itself, health care, housing?
Yeah. I know there's a separate one for the healthcare decisions, but yeah, I mean basically to use funds for.
Now, so that would, those power of attorney, did you make use of it in your dealings with your father and his affairs and his care?
Yes.
Okay.
Oh yes, from time to time. Yes.
I ask that this be admitted, please. Power of attorney. And Madam Clerk, do you have the healthcare agreement? The healthcare agreement. I have a set here.
Yes, that's part of it.
Okay. I should take a look at this, sir, and is that the healthcare agreement we've been talking about all morning?
Yes. Yeah. The
Okay.
home care.
Okay. And when was that? Who prepared that document? Did you do it yourself?
No, I went to an attorney.
Okay. Was it one of the attorneys whose name we heard called here today?
No.
Okay. And pursuant to, when did you decide to have, before I ask you that, in addition to the typewritten, there's a section that's handwritten, sir. Would you tell us what that says?
Yeah, it says that there will be $10,000 payable the first day of each month, but in any case, no less than 3 months, or $30,000 total.
Wait, you're not on the power of attorney anymore. You switched
No,
to
I
the
switched
residence.
to the health care, and I'm asking about the handwritten part that is
The residency care.
your residency care.
Okay.
And there's a handwritten part that he just said what it meant.
Okay.
Ask that this be admitted into evidence.
I think it's already admitted, Your Honor.
Yeah.
Okay.
I think
Yes.
it's actually.
Well, just leave it in the court file for ID. It doesn't matter. Now, when you set up the payment, how did you do that?
Okay, using my father's quote-unquote expense account, and I set it up as a bill pay monthly for 3 months.
So, would you go to the bank and cash a check, or how would the money get from his account to yours?
I think it was a paper check that would come mailed to me.
Okay, I'm going to
You
show.
know, actually, or it could be one of those ACH transfers, but
I'm going to show you what's been marked as Exhibit 3. Does that look familiar to you?
yes.
Would you tell us what it is? I'm sorry, Mr. I didn't show you. It's a 12 account of money.
Right, this is the account, what I call 3728, which was his expense account. And this is for the month of February
Okay. And
2013.
who set up that account?
Oh, the account was originally set up by a money advisor, financial advisor, Schwab. I forgot their names, what their title was exactly. It was some kind of money manager person.
Okay. Did you set up the account, or did someone, or was that an existing account from your father when he was doing his own affairs?
Oh, okay. No, this was different. My father was using Fidelity. After my mother passed away, we changed. My brothers, Steve and I, as the powers of attorney, decided to put the money in the hands of a manager, and he used Schwab, so they changed over to Schwab.
So this account was done with you and your brother working together as power of attorney?
Yes.
Okay. Now, and your brother, as power of attorney, he had access to that account and any other accounts of your father's?
Yes.
Okay. Now, what date? The first transaction to you? What date was that?
Well,
The first $10,000. What date was that?
It shows February 8th.
Okay.
It should have been February 1st, but for some reason, maybe it took a time to set up. I don't remember.
Okay. But are you saying now, under oath, that on February 1st you got monies from that account? The $10,000 pursuant to the agreement?
I'd have to say it probably did not. The check probably did not come till February 8th, as it says here.
Okay.
I'd have to go with that.
I don't want to be technical. I'm just trying to understand when you got the money in your hand, on or about what time. Was your father alive when you got that first check?
Oh, yes.
Okay. Now, when did you get this? Is there a showing of the second check coming out?
No, it doesn't show it on this statement.
Okay. When the second check came out, do you remember what time, what date that was? Was your father alive or dead at that time?
My father had passed away by that time.
And did you get another check?
A third check, yes.
So the 5. And why do you think you earned that first check when he was alive? I asked, well, I'm not trying to be difficult, but in terms, you testified in direct that you went around, looked for places, fixed up the house. Are those some of the things that you did?
Yeah.
Okay.
Yeah.
You mentioned also that you didn't, you took time off from work. How much time off from work did you take?
2 months.
Okay. How long have you been a doctor?
Since 1983.
Okay. Now, why do you believe that he had to come to your house? Why didn't you leave him where he was?
I started to say that before. When he went to the rehab, he had physical therapy a few hours a day, which was good. They worked him, but the rest of the time they would just leave him lying in bed. He would try to get out of bed and fall out of bed. The food, again, it was terrible. He was eating by himself, which he never liked to do. The nurses' aides were pretty rough with him.
May I stop you for one moment? During that time, did you talk to your brothers about the costs and what you intended to do in terms of the care of your father?
I spoke with David about it.
Okay.
Yes. And talked to him about how I had to get the house ready for my father to come and so on. And I told David that, of course, I was going to charge money when he came to live with me. And David kind of shrugged. He didn't have any objection to it.
During that time where your father's health was deteriorating from the time he had the stroke, was your brothers there? Did they compare prices of other places that may take care of him?
No.
Okay. Now, when you wrote, okay, let me take that from you. I asked you earlier about the handwritten note, about payment. Court's indulgence, you want? Court's indulgence. That shows the monies.
Okay. Sure.
show you a skin mark. It's Exhibit 3. I'm going to draw your attention to your listing of healthcare document. Now, do you recognize that as the inventory that was filed on behalf of you and your brother?
Well, it's the amended first administration account. At the time, I was the personal representative. That was the first will,
Okay.
the last will.
Okay.
The first will that was probated, yes.
And subsequent to that, the follow-up, second and third, were signed by yourself and your brother?
Yes.
Okay. Now, and because you two are personal representative of the estate.
Yes.
Now, let me ask you, you mentioned, we talked about first, second, and third. Was the first payment of $10,000, was that a part of the monies, the $20,000 that you were talking, that you were claiming as a creditor? You mentioned 3 payments of $10,000 each. That payment shows 2 payments that of totaling $20,000. And if you may recall the letter that the lawyers wrote about the $20,000, did that include, which one did you drop off? Because you mentioned 3 and not 2.
Yeah, so the first administration account, this is the amended one. The first one would have showed $20,000 for
Why?
Medicare.
Is it because the first 10 was done before your father died?
Yes.
Okay. And was that a part of what you wrote in the contract, that those monies would come at those intervals, the $10,000 each per interval?
Yes.
Is that it?
Yes.
So when you're speaking of the $20,000, you're speaking of you believe that you're owed the remaining $20,000 of the $30,000. You're not. Are you talking about, when you speak before this court, about the first $10,000?
No.
Okay.
No.
Were you ever? Why not?
Well, as I understood, and speaking with the state's attorney and so on, these administration accounts are all expenses after someone is deceased, after someone expires. And that's when any expenses or any refunds or credits, anything that comes in or comes out after a person has passed away, that's what you put into the administration accounts.
Okay.
And this one shows 3571 because it's an amended account, which took into consideration the court's ruling. So
when you read the motion that talked about you're hiding the first 10, did you understand that to be? What did you understand from that?
It was an accusation that, first of all, I was never hiding it. I mean, I interpret it as being an effort with my brothers to make me put more of my personal money back into the estate. I guess. I mean, he tried to say because it happened 2 days before. Okay, yeah.
I'll stop you for a minute. There's no need to talk about what he tried to say.
Yeah.
Well, what he said. I asked that. Click on for me so there's just one exhibit. Could you click that for me so it's just one exhibit? I asked you to take a look at that. Tell us what. Oh, I'm sorry. It's email. into the content because your exhibits have been admitted into evidence, but would you tell us what those are about? Who are they from?
Yeah, it takes me a second to figure out the Gmails here for a second, but it's it looks like a string of 3 or 4 emails between me and my 2 brothers about about some of the matters of trying to settle up, close the estate.
Now, was those emails, were those the very first time you ever spoke to your brother about your brothers about your dad's estate, or when he was alive, what he had, what he didn't have? Is that the first time? Those are new to them?
No.
Okay. And during the times as brothers, and when your father was alive, and when he subsequently died, were there exchanges of information back and forth between your brothers and yourself?
Yes.
During the time that you're setting up the house to accommodate your father, did you say anything to your brother? Did they say anything to you? In essence, I'm trying to get communication if this was just, they were just blindsided by the events.
Stephen had very little contact with me or my father in the last year or so of his life, my father's life. By the time my father had a stroke, I think I spoke to Stephen one time on the phone. He wanted to talk to my father at the rehab, so it was kind of challenging because my father wouldn't answer the phone, so I had to be there. We had to arrange a time, and I got Steve on the phone with my father, and they talked a little bit. But that's about it. David, as I said, I did talk with him about the plans to bring my father home with me.
Was there any decision on your part or actions on your part to ban your brothers from health care, what's needed, what's not needed, the cost of it, where the money's coming from, and how?
No.
Okay. I have nothing further.
Just a few questions. The witness that was on the residency and care agreement, which is Petitioner's Exhibit 2 and Respondent's Exhibit 2, it appears to say Susan Corwin, is that your wife?
Yes.
And that was who witnessed this?
I'll look at it again, but I think it sounds about right to me. Yes, right.
Okay. And this was signed at a time when your dad had a hard time signing things, is that correct? So that's why you signed it for him?
I was my father's power of attorney, and as I understood, I could sign things for him.
So this interlineation on page 1, that was also initialed by you for your father, is that correct?
Yes.
Okay, so he didn't sign that or initial that.
That's correct.
You saw an attorney. Did your father see an attorney? About this agreement, the residency care agreement?
No.
Who paid for the attorney?
I did? Well, yes, I did.
You paid for it. How did you pay for it? What funds did you use?
I have a checking account that I use for my business. I do consulting, and I did this as part of my consulting business. So I use that checking account. It wasn't very much money.
Under the agreement, the court permitted, or under the court order, the court gave you a pro rata amount of $3,700 approximately for in-home residency care from February 1st, the date of the agreement, to the date of death of your father, which I believe was February 13th. Did you disclose to the court that you, in fact, your father was not living at home with you, but was living at Gilchrist at the time?
I wouldn't have said that because that's not true.
I'm sorry, what's not true?
What did you say?
He was not living at Gilchrist?
No.
Where was he living?
He was at the
between February 1st and...
Oh, he was in the respite at Symphony Manor.
Symphony Manor, okay, which is hospice.
No.
He was just an assisted living facility?
Yes.
Okay, so he was not living at your house at that time for that 2-week period?
No, unfortunately not.
There's been no effort to hide financial transactions from your brothers. Did you file a petition for a protective order against subpoenas that were filed seeking financial information on your father?
Objection.
In this case?
Well, that's a separate motion. I mean, we'll deal
I'll
with
withdraw
that.
the question.
Okay. In a few minutes.
No further questions.
Okay. Okay, you can step down, Mr. Dr. Corwin. Okay, let's hear the next motion.
So the motion to strike has been denied, so I think at this point it's the motion. Her motion to strike my opposition to the motion reconsider has been denied, so at this point I think it's the motion reconsider.
Right.
So it would be her motion.
Your Honor, I just wanted to, I noticed that, and I'll just say this in a little bit, that when this court ruled on the motion for protective order filed by my client pro se, it's interesting because the court had no idea what the subpoenas were all about because they were never a part of the record. And what's interesting is, in the way, the power of the court to issue subpoenas is a very powerful one. And in this particular case, there was nothing to file from the other side that those were even issued because they didn't do a notice of discovery. If we're going to do discovery and go by the rules, that's what you do. So in a situation like this, the court would know. And there was no affidavit whether or not it was served or not served. But be that as it may. So when the court actually denied the motion, there was nothing in the record as to what the subpoenas were all about, the nature of them and what they're all about, except for what my client had written. And so when I was hired and entered my appearance and proceeded then to do a motion to reconsider. Because just like any kind of like medical records, you have to do the process of getting the material, and these were his private records. There was nothing at the time, and I said so in my motion to the court, the motion to reconsider, that number one, there was under the rules, there were no matters pending before the court that were contested for which, and the one thing about orphans court is about notice. And the last thing that was there was a caveat. And the caveat was settled, and I put it as part of my agreement, as part of my argument, that was resolved by way of agreement. The parties agree, which is binding on them. And of course, we all know that you just can't go around and change it when you want to. And I think really that's what the parties are doing. And I must say, Your Honor, before I go any further and forget because I'm getting old, is that what's a little bit disconcerting is Stephen Corin, who is the personal representative who signs off on all the documentation that goes out, be it the inventories or whatever, even though counsel will say my client did this or that. They're both signatures because they're co-personal representative. But then he jumps on the other side, and he becomes that interested party who contests whatever is done. And it's such a conflict of interest, and I think there's even case law on the matter, and there should be, that he just can't keep switching around. There's an obligation he has to the estate for which that he must stick to, that's primary, and not do one thing and then run and do something else. So in this case, Your Honor, not only is they should be doing, they're very suspicious of my client. Why are you laughing? I think you should admonish him, Your Honor. You just don't laugh because counsel is speaking. But because even in the motion that we just finished, the language is, he willfully took monies. Now, I know you can accuse people, but I believe that kind of talk from the very inception of this case is what fueled them not to go to the regular process of bringing something notice to the court and then giving notice to everyone and then proceeding. Rather, what they did is do a notice deposition where you go to the custodians and all the records come to your office and they can go through whatever they want to do, seeking something, like in this case. We're saying, like we just finished a moment ago, he took it, he improperly took, he willfully this. And so you put acid onto something that has a regular explanation. He didn't pay it back, therefore he's stealing. So you understand how this kind of language is coercive. And so essentially what I find interesting in this case is that the reasons given for the subpoena is, we know he did something, and lately there's a dubious transactions. Doesn't say what the transactions are. That's so dubious. Obviously, they do not like what they see. They want something else. So it must mean he did something to upset the apple cart, and then make it seem, of course, that something illegal. Now, if they really believe something illegal, they can go to the state's attorney, they can sue him civilly, but orphan court is not where you just try to find all kinds of dirt. Now, for example, I wonder myself, say if they find $50,000 in his account, for example, and now, there's a dubious transaction. The problem is, Judge, this is the intent of Mr. Stanley Coren. It's so not because you don't like what you see means that there was something unlawful, illegal. Somehow these two young men haven't yet discovered Mr. Stanley made yourself liked him better. He was there more. It could be anything. And of course we know in terms of places, one is in Costa Rica, one is in Florida. You don't hear them running back and forth. So here's the young man who is there, and now they don't like what happened. They can't say what happened. Dad gave Stephen the power of attorney. He had the absolute right to go wherever he sought to protect his dad's estate. Not only did he do that, but he also gave him PR rights for his will. So to be talking about dubious transactions, that's something that this young Stephen should have known what those transactions are. They were there. So we just can't keep on throwing mud. Just throw mud, because it doesn't resolve anything. And in the meantime, and I see in here, in their response, in the objection to the protective order, that, we don't need Stanley's account. Not Stanley's account. We don't need Mr. James's account. But we need the ones with his father. His father died. And as this court knows, whatever was account that was, it has a right of survivorship, he doesn't own it anymore. It's all now, whatever it may be, it's all now Stanley's account. Whatever was in it, not in it, there is no cause, Your Honor, because all they wish to do, it is totally un-American to have you just keep poking around until you find something that suits your fancy, when you can't even allege what that wrong is that he did. And so, Your Honor, it is the reason I filed for the reconsideration, because one, the court needed to see the subpoenas that were filed. They are all-encompassing. I don't know if you have that in your. It should be there on mine.
Yes.
The several. Okay. Now, the last time, what I thought was interesting is I attached 2 letters because once the court denied the motion, counsel then contacted the custodian, which is pretty much your right. They have the order in front of them. And I attached it to my latest motion to dismiss, saying, send on the record, everything is good to go. Since that time, I have not seen an update yet that says, hold off a minute, because there's still more litigation. That is just not the response. A responsible lawyer, what a responsible lawyer does. And it's wrong. And as I'm standing here, you fight the feeling that people believe that because you don't want someone to see something means that you're hiding something. But I know this court is more sophisticated than that at all. Because what's interesting, if he became a thief, it wasn't just after he could have been stealing everything. He could have been doing so many things. But the point is, all these 2 men, maybe they chose not to do what they needed to do. And I find it interesting, Judge, because the 2 kind of ties in together. The wanting information. The one they claim is a transaction, the only one in front of you today, is one which they knew all about. The Schwab account was there before Dad died. The money came out before Dad died. You'll see in the back and forth, emails back and forth, they talk. These are something that they do. And so essentially it's rather they're not here, they've never been here, so you can't get to see who and what they are, what's behind all of that. But if he's been stealing for so long and all that they can come up with is this doctor stealing $20,000. And what's interesting about it, Judge, whereas you may say to him, he must pay it back, put it back in the kitty. That money is accounted for. You know what the ruling was, whether he likes it or not. And by the way, it's 3 payments. They're talking about 2 because one was before he died. So no matter, so he puts it in the pot or not. But the bottom line, Judge, is that, I'm getting old, I really am. But what's interesting is that for all the things that they claim is dubious, that's all they have here, because that's all they can do. And it's something that they've known all along. And I think what's the most important thing that I want this court to understand, be it the motion, this case has been going on for a couple of years now. It's just been going back and forth. I've seen where the same motions keep coming up. Remove him. Oh, we've worked it out. It's just the same thing, rehash, recycle. And but what is clear for these purposes is that, and they say it in their motion and their responses, they're looking for something. And they're not sure what they're looking for. And that's not what discovery is all about. And we could go on and I go look into theirs and check on back and forth. It does nothing because he has access to Standard's account. Nobody wants to do that, or nobody believes that. They've had a lot of time to see what is there and what is not there. And of course, this is a case which the court may or may not know, it's not before you right now. A substantial intervivus gives the death. Substantial. The one person who didn't get anything is David. He should be on his own mad. But it was substantial money, not just to him, but so many other people. And so I asked the court to consider my motion to reconsider. give the appropriate order, because there's really no reason to have you go hogwash about every single account that he has. That's a man's dignity. And I know brothers fight and all that, but those days when you jump on the bed, the bunk bed and hit each other in the head, those are over. These are grown men, grown wives, grown lives. We don't play like that. And we know that people can do with it, know about this whole... It's happening already. It's happening. And so, but this is not the place for it, is what I'm saying. And it's really, I think, I submit on what I've written about the motion for show cause order, and motion to reconsider, and I just said if council's going to speak, if he says, we want to see that account from June 6th where he did with this such and such, where you can have something tangible, rather than go through his entire life. What are you going to do with it? Why do you want it? You wouldn't do it with medical records, but it's just as private.
Thank you, Honor. You started the hearing by saying, is there a reason to change the ruling? Are there other assets that have not been revealed? And that's what we believe has occurred. You've heard testimony today where already there's been several misrepresentations to the court, the first of which was that even if $20,000 was paid from the estate, $3,000 of that this court allowed for that time period when he was actually alive, they didn't disclose that he was in fact living somewhere else and wasn't in home as had been contemplated. That's the first misrepresentation. And I apologize in advance for characterizing and making an argument for my client because I know it's going to offend them. But the fact is they did not disclose that. The second thing that they didn't disclose is that there was already $10,000, which would have even paid that $3,000. So we know for a fact that $20,000 was taken from the estate without justification, which was not fully disclosed to this court on a show cause order. They should have been articulate and conscious and aware that when you take $30,000 from an estate, you need to disclose why you did it fully and not partially and not not in a piecemeal fashion that requires the court to figure out what happened or the other side to step up and finally say, hey, they haven't been honest with you. In fact, we didn't even know about that additional $10,000 until we did a subpoena. And that's why we do subpoenas. She says it's not a fishing expedition. That's what discovery is. This is a PR who has shown himself to exercise his power of attorney for his own benefit, seeking his own lawyer without having the father involved, without having the brothers involved. And so when we hear what she says about there were substantial inter vivos transfers, that's dubious. We have a history of 5 to 6 years of dementia. He was at advanced end-stage dementia on February 1st when this contract was signed. What other undue influence was exerted on this man which is taken away from the estate? Substantial inter vivos transfers, which we will investigate, and which we are investigating. There was an order requiring money to be repaid. We were investigating that. Where's that money? Where has that money gone? Why has it been repaid? Why hasn't it been repaid? There was that failure to return the money. There are exceptions to the account. There's this motion to compel repayment. And there's other things coming. I want to step back for a second and talk about 2 things that she said. First is she said we didn't disclose to the court the extent of what we sought. We did. On page 2 of my opposition, I said we sought the financial records of A, B, C. On page 3, I said we sought the financial records of A, B, C. And we actually outlined what it was. We didn't prevent Mr. Corwin from filing those subpoenas. Sometimes people do that. He chose not to. She acts like we somehow have hidden that. We disclosed what we sought and why we sought it. And this court granted us the relief. The second thing she talked about was the ethics and the conflict of interest. I represent the individual. The PR's counsel is right there. There is no conflict of interest for an individual who is both 2 hats. He has 2 counsel, PR, individual. I represent him individually.
I'm talking about Stephen.
I'm talking about Stephen. And David, I represent an individual as a beneficiary. I represent them. How that becomes a conflict of interest or is in any way confusing is beyond me. I don't even know how to explain it other than to state that I find it egregious that ethics violations have been alleged here today for something that is completely typical and normal in estate disputes, which I've done many over the last 20 years. Then we get to this question about the custodian of records and the letters that I sent that she felt compelled to attack. What she didn't tell you was that after I received the order and her entry of appearance, I contacted her and I spoke with her. And I said, great to meet you. I'm glad you're involved in the case because good lawyers can get cases resolved. And I was glad that he got a lawyer because sometimes lawyers can help their client understand the risks they face and the jeopardy they face when a show cause order for a motion to compel payment is facing them. And I said to her, I just got this order on the motion for protective order, and they denied it. Do you intend to file a motion to reconsider? I asked that specifically, and she said, in this strange way, I'm old, and I don't know, but I don't think so. I'm not given any instructions. So the next thing I do over the next couple days, and I wait a few days just to see if anything changed, I file my letters. I spend over an hour sending letters to all these custodian of records, having to address the chaos that he's created by sending this order, or this motion for protective order to all these people, spending that money. Then, out of the blue, with no contact, no letters, nothing, I get a motion to reconsider after having a conversation with her, saying, let me know if you're going to do this. So I spend all this money, and she has the nerve to come to this court and to say that I did something wrong. And when she didn't follow up with those letters, she was CC'd on my letters. And she doesn't mail them. That's her burden. She's moved to reconsider it, not me. It astounds me. And it's frustrating because it is so clear that there has been wrong done in this case. The undue influence, the fact that he was not oriented to time, place, or person on the same day that that agreement was signed for a check for $30,000 was basically cut, is astounding behavior. And whether you want to call it wrongful or unlawful or just plain wrong, it is what it is, and Your Honor knows it. And I just believe that there are other things that happened. There is enough information that we have in front of us to know that he has not been forthright as PR, and we've issued subpoenas to get to the bottom of it. And we seek that the motion for reconsideration be denied, to permit us to continue to investigate to find out what other assets have not been fully disclosed to this court, which so far we have a history of non-disclosure. Thank you, Your Honor.
So before you finish,
can I?
Yes,
Can I
just a second. You chose dates of 2010 to present. What's the reason that you chose that date?
We have a history documented in the Gilchrist records that showed that he had a history of dementia of 5 to 6 years. So we're going back, we're seeking not only financial records, but medical records, going back 5 to 6 years. And it's part of the forensic process that we do. The first thing we do is we figure out what bank accounts, what assets he holds during that period of time. We figure out what medical records support it. And then we look and we start to see about him and those transfers. And that's what we're reviewing. Because we don't know when he became incompetent, but we believe there was, again, in 2010, a power of attorney that was entered into, presumably because he saw the future coming. At some point, that future became a point where he was unable because of his stroke, because of his vascular dementia, because of his Alzheimer's dementia, which you heard testimony about. That didn't happen overnight. So we go back 5 years for both records, financially, and for medical records. And that's what we saw, and what we continue to seek, and what we'd like to have in this case. And we intend, we just got the Gilchrist records, they give us information on additional doctors. We'll subpoena them. Eventually, we will find out the full extent of his medical condition and the full extent of monetary transfers which would impact the estate. Thank you, Your Honor.
Your Honor, that's the reason one needs a hearing. You know? Because we just records say this, we use it to say that. Here's a man, it's a doctor who says this one says that. That's why we put experts in this, that we go through them. But the one thing that we do know is that Stephen, his client, and David agreed that the 2011 will is the will. which means he's competent, he's able, he is knowledgeable. They all agreed on that. Let's not rewrite history. And that's why you just don't send off with stuff. Because here we're talking, I came in here for improper. We're upset about improper. Now we're hearing about all these forms of dementia. My client's a doctor. He can get all the different stuff. I could have asked him to do that. That's why we have hearing. That's why Estates and Trust says when there's an issue, you just don't decide that it's contested. You put it on the stand and we talk about it. Look how we're going at it now. I don't believe what he's saying. I have stuff that I could have said. So that's why you have a hearing judge. You just don't go ex parte through him. Because it has to be fair. You just don't walk. I mean, how much does well, I said the prosecutor, so used to saying that. How much does he say Mr. Stanley has? $10 million? Because you know what, Judge? I can't believe, you can't believe me. I can't believe you. Your Honor, the intervivors, I thought there would be no discussion about that, because everybody knows that Stephen got $600,000 because he wanted, and there are letters from Mr. Stanley giving the children, his grandchildren, because after his wife died, that's what he wanted, giving his children the money. They all got the money. The only person who didn't get the money is David. All those are monies he gave them through death. I mean, before he died. Don't just say now, because I know Stephen got his money. He was supposed to give David somebody didn't. And then that's what we want to investigate. That is just sad. That is really sad. And it just shows you the need to be responsible as a lawyer, because you can further stuff. And I know money make us crazy. We want everybody's money. We want to, in Jamaica we call it the dead left. We fight about that. But, we've got to be real. We just don't walk in on what he says because he got something, because those records are vast. And they were known. They were known to David. Stephen had the power of attorney. He could have gone and says, what's this? We saw the paperwork that my client, and you see through the emails, that they talk about it. I know you want to put it as if there's something interesting. And Stephen knows what he got. Stephen knows what he got. And to suggest that you want to investigate that, I know it's a political year and people say stuff that it sounds interesting and cogent. But he talks about me, and that's not right. I just came in the case. I don't know this man. I've dealt with lots of people like this man who, have an agenda, and it just shows, I'm all I don't know. I run my own practice. I've been a lawyer for 30 years. And when I don't know something, I say it upright. So it is totally beyond the pale of what we're doing to come in here and say it's my fault. No, there's no fault. There's a process for issuing subpoenas, and it's in the rules that when you want a production of documents or a records deposition, there's a way to do it. There's a notice that's given to the court in the file. So I'll know. And so when I go to check the list, I'll know because I go and check it regularly. And when you serve them, you do the affidavit. That's what we do because you never know what action comes. Don't put it on me. There's no need to put it on me. Before I came here today, because that telephone call, I literally told him that he wasted my time and I wouldn't bill my client because nothing he says was of value. But I want him to know, and the court to know, that when we first talked, he mentioned the order. He didn't have a copy of the order for denying the motion. And I promised him that I'd come over and get a copy, and I'll fax it to him. He got it. Because not only did he get it, but he made it, a copy of it was, and my fax cover is on those letters he sent to those custodians. Now, he forgot that. I made him a promise. I committed to it. That's what lawyers do. It's not about friendship. Well, if you waste my time, I'm going to tell you. And what I see here today, Judge, We may never talk, but I do know what my responsibility is. I'm sorry to go on about me. It's not supposed to go on about me, but somehow I became a part of the argument. And it makes me sound brain dead. I wanted 4 more years of my license. I'm going to submit on the motions that I've written and the responses. And I'll say, Judge, it's not very complicated as much as advocates, because that's what we are. We go back and forth. You are the judge. You have that responsibility to make sure that what is right is done. And I'm sure you've heard it all before, everything before. And so I trust that the decision will be, tempered in what it needs to be. I'll submit, Your Honor.
Okay. I will review everything, and I'll issue a ruling at a later time.
Not today?
No, I have a lot of documents I want to look through.
Thank you, Your Honor.
Okay.
I have 2 exhibits, the respondents to the petition. Thank you for your patience, Your Honor.
Thank you.
Just so we're equal, Your Honor, thank you for your patience.
Okay. You ready?
All rise. The Orphans Court for Baltimore City is adjourned.